Joining me now to discuss all this is David Aaron, former prosecutor in the DOJ's National Security Division and a former Manhattan Assistant District Attorney, and Ryan Riley, NBC News justice reporter, who was inside the courtroom for today's hearing. Thank you both. Ryan, let me start with you. On paper, it feels like Judge Chutkan is sort of a wet, not a wet blanket, but a cold dose of reality, perhaps, to some of the fantasies that the defense team has been having about the case they could make to her on a number of fronts. What can you tell us about her general posture towards the defense today?
There's definitely a lot of side eyes, I think, from some of the lines that we saw coming from Donald Trump's defense. But really, the word of the day to me, I think that she used 6 different times, was yield. And that means that the defendant's other rights, his First Amendment rights, must yield to the process of this court, must yield to the administration of justice. And that basically saying, listen, all these concerns you have, playing second fiddle here. They are not my main concern. My main concern is making sure this case goes forward, making sure that this case is handled fairly, and making sure that we can get it to jury trial. And like you said, it was that carrot and the stick sort of situation where, you know, theoretically, in any other case, you would have that idea of potential contempt of court coming down. And that is something here. But of course, you know, it's hard to imagine us getting to a scenario where where the judge is actually going to lock up Donald Trump pre-trial, but that is potentially something that would go down the line. But I do think that that could be a better way of sort of enforcing this. Judge Chutkan saying, listen, the more that you violate these rules, the quicker we're going to have to go here. And there's a very logical reason for that, because future comments could spoil the jury pool and make it more difficult to get a fair trial going in here. Of course, Donald Trump doesn't want this case to go to trial in D.C., but the rules in D.C. are, hey, we're going to try to seat a jury. And that hasn't worked in any of the January 6 cases that I've covered thus far, where that's just really been shot down, and that the voir dire process can actually work. If you have jurors swear an oath and promise that they will obey that oath, they can handle these cases fairly.
Yeah, I feel like she really went for the defense's Achilles heel by suggesting, not talking about fines, not talking about jail time, but talking about the thing that they do not want to do, which is have a speedy trial. Dave, what is involved in, I mean, I guess for those of us who don't understand the sort of length of time that is minimally required to have a federal trial, I mean, how reasonable is it to say, I'm going to move this date up the more you infringe on sort of the protective order? Like, what practically can that mean?
I think there are limits to what it practically can mean. I mean, it's not as though every time there's a violation, the trial date gets ratcheted 2 weeks earlier. You know, that would just not be workable. I think it's more of a thematic or general point the judge is making, that, you know, there are inevitably moments leading up to a trial when schedules have to get altered one way or another. And one thing that the judge is going to be thinking a lot about is the costs of delay. And here, the judge talked very explicitly about a very, very significant cost of delay that could be fundamental to the fairness and efficiency of the trial.
Ryan, I was struck by the fact that she sort of dismissively suggested that the former president's bid to be president again was a day job. I mean, up until this point, I think that there has been a sort of deference, at least in terms of narrative, to the idea of Donald Trump's campaign in 2024. But Judge Chutkan seemed completely uninterested in that. And I wonder how that squares with her posture generally towards other January 6 defendants.
Yeah, that was very interesting. I think she was sort of searching for a term or a word at the moment, and that's what she sort of stumbled on. And it, you know, is probably an accurate description, and that's probably how she thinks of it in terms of other cases that are handled, right? Like, this isn't something that he needs to do. This is something that he wants to do. Right? The priority, she kept saying, was the courtroom proceedings. The priority isn't litigating this case in public. That's not what this trial is ultimately about, and that's what she really wants them to get their focus on. And certainly they have the First Amendment right to talk about the charges in general, but she really wanted to make it clear that you cannot violate those rules and intimidate jurors, as we've seen Donald Trump do in the past. And it's interesting because I do think that the judge is in quite a spot here in terms of some of these threats are certainly going to be directed at her. Donald Trump has already made clear that he wants a different judge and that she shouldn't have been assigned to this. That's not something that you hear his lawyers arguing in court. And that's something that the special counsel's office pointed out, that there's already this divide between what Donald Trump is saying on Truth Social and what his lawyers are actually doing in court. And that's going to probably be a split that she would probably like to bring in a little bit, right, and bring them back on the same page. But really, ultimately, I think that there is this huge combination happening right now between the legal and the political, where it really is the whole ball game, I think, when this trial ultimately gets set for, because they're sort of wanting to make the election stand in for a jury trial here.
Yeah, clearly, for many reasons, right? Dave, I'm struck by Ryan's, when we talk about the various judges' postures towards Donald Trump and how Trump would like a different judge on this. Presumably, he'd like someone more like Eileen Cannon. And I think what the American public has right now is a study in terms of two federal judges, right? One, Eileen Cannon, thus far in all her rulings, has seemed deeply deferential to the fact that Donald Trump is running for president. And here we have Tanya Chutkin in Washington, D.C., who's taken almost the opposite tack, as Ryan explained, just kind of so what if you're running for president? I guess my question is, which do you think is more unusual in terms of staking out a position towards this 2024 presidential bid?
I mean, it's unusual for a judge to have to take a position on the defendant running for president, of course. I think what we're seeing in D.C. is a reflection of the truth in every criminal case, where the defendant has plenty of other things to do and plenty of other things going on in their life, rather than show up in court, abide by court rulings, obey the judge's orders. But the judge is really having none of that in D.C. That's playing it down the middle. There has been, I think, a little bit of flexibility given the realities of the position that the former president is in and some of his needs to be able to speak. But when it comes to anything that would affect the fairness, efficiency, witness safety, witness security, integrity of evidence, this judge is going to be applying the exact same rules that she would be applying in any other case. And I think as an experienced former public defender, this judge has seen quite a lot. She's seen a lot of defendants. She knows a lot of how different defendants behave, some of their tricks, some of the pitfalls of how defendants might behave, and she knows what control has to be exercised over a defendant consistent with that defendant's First Amendment and due process rights.
Can I just follow up on that, Dave, in terms of the protocols that she's established here? The notion that Trump has to have his defense counsel babysit him effectively when he's looking at sensitive material, that they have to check his notes if he takes any when he's looking at the materials. How unusual is that?
It was in the prosecutor's proposed order. In my former career, in the context of classified information, that was definitely the kind of thing that you'd see in there. What really struck me here was the red line version that the defense proposed to the judge, where they sought to strike out explicitly that chaperone or babysitting or hall monitor provision. And the judge, this isn't just the judge accepting a document that was presented to her and signing it. This exact clause was litigated. This was redlined, and the red line was rejected. So this judge, regardless of how it might go in any other case, this judge was squarely presented with the question of, does she have confidence enough to allow the former president of the United States to take notes that are appropriate? And this judge decided no, that the judge only has confidence or would only have that confidence if the former president's attorneys scrubbed his notes and made sure that he hadn't written down anything he wasn't allowed to.